Major breaking news in the United States Supreme Court. 20 states plus the District of Columbia have filed an amicus brief in support of Merrick Garland and the ATF and the Joe Biden administration in the case of Garland versus Vanderstuck, which of course is the case involving Joe Biden's attempt to expand the scope of what a frame and a receiver is by regulation to cover so-called ghost gun kits or weapons parts kits. So far, Joe Biden has been totally unsuccessful. The ATF has failed because the lower courts have refused to allow this to go into effect on the grounds that it violates the law and expands the scope of the ATF's authority beyond what congressional statutes have permitted. Nevertheless, Merrick Garland is seeking a stay of the lower court's order in the United States Supreme Court, and just now 20 states plus the District of Columbia have filed an amicus brief in support of the administration and this unconstitutional violation of the Second Amendment and more. Stay tuned. We're going to break down this brief in a moment. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of the brand new best-selling book, Disarmed: What the Ukraine War Teaches Americans About the Right to Bear Arms. And don't forget to follow me on Twitter at @4boxesdiner, where I put out even more Second Amendment information than I can on this channel. Okay, breaking news is this. You know, there's a pending emergency application by the United States Department of Justice in the case of Garland versus Vanderstuck. This involves the so-called ghost gun rule, which is really a political propaganda term by the anti-gun community to basically disparage people who want to make their own firearms, which is a constitutional right. Now, this brief submitted by 20 states and the District of Columbia includes some really a lot of the usual suspect states like California, New Jersey, but it has some other interesting states I want to flag for you. Specifically, the 20 states that have submitted this brief are the District of Columbia, no shock there, New Jersey, Pennsylvania, kind of interesting there, California, Colorado, Connecticut, Delaware, Hawaii, Illinois, Maine, Maryland, Massachusetts, Michigan, Minnesota, Nevada, New York, North Carolina, Oregon, Rhode Island, Vermont, and Washington State. So these are the 20 states plus DC that are standing up and saying that we support the unconstitutional expansion of the definition of what is a firearm by the use of regulations to somehow effectively amend the Gun Control Act of 1968. Now, this brief, I'm happy to report to the Second Amendment community, is basically a puff piece. This is a PR document that's allowing the attorney generals of these 20 states to issue a press release that they're tough on quote-unquote gun violence, which again is another propaganda term, and that's basically what this is all about. This is not going to impress anybody at the Supreme Court. I read this. It's perfectly fine as a written work product. There's nothing offensive about it other than the mistakes I'm going to get to in a second or the things that I think they should have talked about, but they didn't. But the bottom line, this is not going to be any marginal benefit to Merrick Garland. Again, this is really a press release gussied up as a legal brief. That's what we're really looking at here. I'll put a link to it down below so you can check it out yourself. So that's the first general observation. The good news is it's not particularly great, not going to advance the ball or move the needle in favor of the gun controllers in the Biden administration. So that's good news. A couple other things, though, I do want to flag. What's kind of interesting is there's a lot of things that they don't mention here. So, for example, this brief spends a lot of time talking about ghost guns. But again, no one really talks about what ghost guns are. What they try to include as a definition of ghost guns, of course, are what are really known as unserialized firearms. But as you know, before the year of our Lord 1968, the vast majority of firearms in the United States were unserialized. Now, this is particularly important because, as you know, and we've talked about this before, that unlike, let's say, eggs or milk, okay, firearms are what are known as durable goods. In economics, there are certain things that are durable goods, and there are certain things that are like consumable products. And again, eggs, milk, butter are consumables. You know, you have to use them with some speed because they don't last forever. In contrast, you know, firearms going all the way back will still fire. Certainly World War II guns will still fire, and I'm sure a lot of you guys out there can fire guns that were made even before World War II. I'm probably not capable of that, but you guys are. So the bottom line now is these are durable goods, and this is particularly important because when you look at these briefs submitted by the government and by these amici here, they don't really distinguish in any real way the difference between what are known as self-made guns, privately made firearms on the one hand, versus guns made before 1968 that did not have serial numbers versus firearms that had serial numbers at one point, but they were etched off or crossed off or erased, nailed off, filed off by criminals for criminal purposes. They don't draw the distinction between those three different categories. They try to all lump them together. The reason why, of course, they all want to lump them together is they want the numbers to be as big as possible to try to get the Supreme Court to think this is a bigger quote-unquote problem than it really is. That's the first thing that stands out as I read this brief. No distinction between those three categories of what would be known as unserialized firearms. They all lump them together under the political propaganda term and label of ghost guns. That's the first observation. The second critical observation about this brief is this. They spent a lot of time, and this is very interesting, I think this is going to backfire on them. They spent a lot of time talking about the legislative history of the 1968 Gun Control Act. Now, legislative history, I'm not going to bore you with the details, but the best evidence of legislative history, of course, is the text of the statute enacted by Congress. And you understand in this case is very important because Congress passes a statute and regulations are allowed to be promulgated under those statutes, provided that the regulations are consistent with the statute and do not contradict the statute in any respect. And that is a big argument here, that under the congressional statute of 18 U.S.C. 926, little a, whether or not the ATF's regulations somehow run afoul of that. They almost certainly do. The lower court said they did. Now the question is before the Supreme Court. Now I bring this up because in this brief by these 20 states in the District of Columbia, they talk all about the legislative history of the 1968 Gun Control Act. They talk about the assassinations from the 60s and all sorts of things. What they probably didn't anticipate was that a handsome YouTuber would actually read this and analyze this. And the truth is, I've now done so. And let me tell you what's not in this brief. What's not in this brief is a discussion of the amendments to the 1968 Gun Control Act that occurred in the year of our Lord, 1986. And when you're a court, you obviously are dealing with the most recent laws because those are the laws that are in effect. So what happened between the year of our Lord, 1968, which is what this brief talks all about, and today? That is the Firearms Owners Protection Act of 1986, which specifically spanked the ATF for bad behavior and for abusing its discretion, because the language of 18 U.S.C. 926 before 1986 was much broader and more forgiving and gave a lot more discretion and authority to the ATF to do certain things in terms of promulgating regulations under that statute than it does today, because up to 1986, the ATF abused its authority, and Congress wanted to nip this in the bud and stop it. So therefore, in 1986, they passed the Firearms Owner Protection Act that amends the statute. Now, the question is there any discussion of the Firearms Owners Protective Act in this brief by these 20 states? No. Is there any discussion about the fact that the Firearms Owner Protection Act of 1986 shrunk, narrowed, and limited the sorts of things they're talking about from the year of our Lord, 1968? No, not in there. No discussion, not even mentioned, not cited, nothing. Nada, zero. Why is that? Well, either they decided that they didn't need to talk about it or they didn't think about it. Who knows? Nevertheless, the bottom line is that is a major omission that I think the U.S. Supreme Court will take notice of because, again, the Supreme Court, they're not dopes. They're very sharp, and they're going to catch the fact that this talks about legislative history of 1968, but skips over the text of the 1986 laws and the legislative history of the 1986 laws that, when you look at that, specifically talks about cutting back on the authority of the ATF because they misbehave all the time, which they're effectively doing in promulgating ghost gun rules rather than going to Congress. That's the first thing that I noticed in this brief that clearly is going to stand out as a problem for the Supreme Court. The second interesting thing is, you know what I did not see anywhere in here? Is a discussion of the Second Amendment. Now, yes, this is a statutory case dealing with administrative law. That's all true. The reason why it's interesting, though, is that there are cases on the books already that we as Americans have a constitutional right to make our own guns. Specifically, as you think about the text of the Second Amendment, it says we have a right to keep, which means to have and possess, and the right to bear, which means to carry arms, including firearms. So how, since we're not born with guns, we have to be able to acquire these guns in order to keep and bear them. And we know that the way you acquire guns is you can inherit it, you can buy it, or you can make it. These are all ways of which you acquire, and there's no regulations on these at the time of the founding, so all three things are constitutional. And now this is interesting because you've read about this judge quite a bit in the news in a favorable way. Judge Mary Ellen Norica is the judge presiding over the Hunter Biden case in the United States District Court for the District of Delaware, and she was considered to be very good because she's the one that uncovered that sneaky language that the Department of Justice and Hunter Biden's lawyers put in part of the plea deal that really did not see the light of day until the afternoon. But she read it and caught it and realized that there were some games being played, and she nipped it in the bud, and that's what blew up the plea deal. The reason why I bring up Judge Mary Ellen Norica in this context is because she is the judge that struck down the Delaware state ghost gun law on the grounds that it violated the Second Amendment. Now, Delaware, I should note, is one of the states that submitted this amicus brief to the U.S. Supreme Court. Now, is there anything in this amicus brief that refers to the fact that Delaware, one of the amici in this case, got its butt kicked by Judge Norica in the United States District Court for the District of Delaware, striking down their state's ghost gun rules as unconstitutional under the Second Amendment? No, it's not in this brief. Isn't that interesting? Again, another interesting omission that I suspect the Supreme Court might take note of. Again, technically speaking, you don't need to get into the Second Amendment here, but of course, all this is a moot point if you change the regulations in such a way that violates the Second Amendment, because of course, yet another reason why this is not allowed. But let's carry on. The next interesting thing about this brief I want to flag is that they go right into interest balancing. At page 1, this is going to turn the Supreme Court off like that. I'm telling you, like that. The opening paragraph of substance in this brief starts out with the following, quote, "In recent years, gun violence, propaganda term, no such thing as gun violence any more than car violence or anything else, okay, but anyway, set that aside. In recent years, gun violence has skyrocketed across the country. Gun-related homicides rose by 45% between 2019 and 2021, blah, blah, blah. The Supreme Court has made it clear, hello, no interest balancing when it comes to guns. The good and the bad of the guns, of course, have been balanced out in the context of the Second Amendment. Nevertheless, they're talking about gun violence propaganda term. And again, the Supreme Court's going to see this and be like, yeah, we get it. People can misuse guns. But here's the thing that's going to backfire on them, because they talk all about, these quote-unquote ghost guns. Then they go on to say on the very next page that under the current law, a person explicitly banned from firearm possession under the Gun Control Act can still buy a kit, a weapons kit, and assemble a fully functional gun within hours. This is going to actually hurt the anti-gunners, strangely enough. Why is that? Because they are playing into the famous philosopher that I wrote the most powerful article about, I believe, involving the Second Amendment, Cesar Beccaria. Cesar Beccaria, of course, wrote the famous article that says that gun ban laws, help the criminal at the expense of the law-abiding. That was written before our founding. That man, Cesar Beccaria, was so important that both John Adams and Thomas Jefferson wrote down his words and used him in the context of crafting our Constitution, including, yes, the Second Amendment right to keep and bear arms. And this just proves the point that the Supreme Court has noted before, that passing gun control laws will not stop criminals from doing criminal things. We've known this since long before even the founding of our country, and the Supreme Court has recognized this. And yet here you got these 20 states in the District of Columbia are immediately trying to talk about bad people can violate the law. Yeah, that's what they do, and no law is going to stop them. If they want to commit murder or they want to get a gun in violation of this federal statute that's already on the books, that's 18 U.S.C. 922G, and let's say they're a prohibited person, they're not going to care about this. If they're going to violate the law, they're going to do it anyway, and the Supreme Court's going to immediately catch on to this because they get it. The next thing I want to mention that's interesting is how this is very important. It's going to get a little geeky here. I believe that the argument that the anti-gunners are making in this ghost gun case, both these amici and the Department of Justice, is they're reversing causation. I need you to pause and listen carefully to this, because this is going to take a moment. It's going to be easy to understand, but it's going to take a moment to catch. It's going to take a moment to get. All right, here's what you got to understand. In these arguments about the statistics involving ghost guns, the anti-gunners argue this. They say, we are finding more quote-unquote ghost guns in the hands of criminals and at crime scenes than ever before. Okay? That's what they're saying. Now, here's the thing. They are not saying that the ghost guns are being used to commit more crimes than ever before. You hear what I just said? They're not arguing that ghost guns are being used to commit more crimes using ghost guns than ever before. That's not really what they're saying. I don't think they have the facts to make that argument. What they're saying is that more ghost guns are being discovered at places such as crime scenes than before. Now, what is the point of this? What is the point that Mark is making here? What happens, I believe, in most of these cases that I've seen, is that the criminals are caught with drugs. They're caught in a drug den. They're caught doing some illegal act. They're caught at home. They are arrested. After they are arrested for some other crime or some crime, there is then a search conducted of the criminal's apartment, of the criminal's house, of the criminal's car. In the context of that, ghost guns are sometimes uncovered. You see what I'm saying? This is extremely important to understand, because what they're trying to argue in these briefs is that ghost guns are harder to trace, and we need to be able to trace these guns to catch the criminals. But the reality is they're catching the criminals in the other methods always done, which is eyewitnesses. They're caught on CCTV cameras. Their friends turn them in to get a better deal in a police sentencing arrangement, whatever it is, or police informants catch these people. These people are being caught in other ways, as always, and not through the tracing system. And as they're caught, these unserialized firearms, many of which, by the way, are simply just crossed off, etched out serial number guns, right? They don't draw that distinction in any respect. They're getting caught that way. They're not getting caught because of the ghost guns. The ghost guns are being found because they're getting caught from other things. So even though they may have these ghost guns, there's not a lot of evidence that these ghost guns are being used to commit crimes. Yes, some of them are. Yes, they have been used. I'm not denying that. But again, when you look at the data, it's also unclear as to whether or not those ghost guns are really privately made guns, or again, they're one of these other guns from pre-68 guns, or again, they're just crossed off serial numbers from guns that had them in the first place. That data is very fuzzy, and I think the reason why that data is fuzzy is because the anti-gunners in America want to keep it fuzzy for obvious reasons, because they want their numbers to go up. It's kind of like the notion of COVID. The bigger the numbers were, the more there was reported, the more you talked about in the papers, the more the diagnosis flowed in, among other reasons. Nevertheless, you get the idea that when you talk all about a topic, you're going to get a lot more reporting. And I think that's a big part of this bias that we're seeing with the increase in the number of these kinds of firearms. It's not that they're out there in greater numbers, maybe they are, but I suspect the real reason is the reporting numbers are going up, but the actual numbers of guns are not. They also have admitted that they don't think you have a right to a gun in any respect, because if you look at page 16, they say the final rule, which of course is not enacted by Congress, stops a growing segment of the modern gun industry from exploiting new technology to widen the very gaps that the Gun Control Act sought to close. So here we have the gun industries exploiting new technology to widen the very gap that the Gun Control Act sought to close. The idea being, of course, that they're exploiting the right of Americans. None of this talks about the right of Americans to keep and bear arms. None of this talks about the right to acquire guns. They think that you should be privileged to have a gun, that you should be privileged to be able to make your own gun. They view any ability of the Americans to exercise their right to keep and bear arms and to acquire it as a privilege, and that if you get around the system that requires the 4473 paperwork to be filled out so the government knows who and what's going on, they think that's an exploitation of the system. Of course, that's what they think, because they want to make sure the serfs are serfs and not civilians. But we as Americans are civilians and not serfs. But of course, sometimes in briefs like this, the message is clear. They view us as having no right to keep and bear arms, no right to make our own guns, and they think that if some criminal somewhere can misuse the gun, we should be denied our rights as Americans. But that's not how the Constitution works. And I think the Supreme Court's going to see through this brief, which again, at the end of the day, I think is just a glorified press release for the attorney generals of those 20 states in the District of Columbia to talk about how well they're doing with their constituents. All right, folks, hope you learned a little bit something here today at the Four Boxes Diner. If you haven't subscribed, please do so. We're trying to get our numbers up big time. We're working hard at it. And again, we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.